Hello and welcome to this Field Seymour Parks webinar. This is part 2 of a 2-part series, the sequel if you like, on redundancies, and redundancies particularly in the times of the current pandemic. So the focus today is on collective consultation. Before we crack on, as we've got a fair bit to get through today, just a few things to flag in case you weren't on the earlier session this week. Firstly, if you do have any questions, please do type them into the question box as we go along. I'll open that up at the end of the session, and I've left some time, or will leave some time to make sure I answer as many of those as possible. There'll also be some polls. Well, I'll be asking some questions of you, and they'll pop up as we sort of go through the session. So please do get involved with those and give me your feedback and views, because that's great to hear. And then if you want a copy of the slides you're going to see, you should be able to download those from the handout section in the GoToWebinar toolbar. Right, well, let's crack on and talk about what we're going to be looking at today. So, in broad terms, we're going to start off by spending a bit of time at looking at when do the obligations actually apply? When do you need to be worried about these obligations to collectively consult in a redundancy situation? So we'll delve into that a bit. Then we'll look at, well, what do you actually have to do? So we'll look at the obligations to notify the Secretary of State, how you handle representatives in any elections, and then we'll look at the information you have to give and the consultation process as well. So we'll break that down, and then we'll finish off by a brief summary of sort of the risks and the reasons why it's important to get this right. I should say what we won't have time to cover today is if you have a formal information and consultation agreement under sort of the ICE regulations, won't have time to get into the details of that today. But that is something to check whether or not your organisation has something like that in place. You'll probably know about it if you do, but that would informing and consulting under that type of arrangement will be separate to what we talk about today. So let's move on. When do the obligations apply? When do you need to be worried about any of this stuff? Well, in simple terms, you can see on the slide there, it's when an employer is proposing to dismiss as redundant 20 or more employees at a single establishment within a period of 90 days or less. So that's all quite straightforward then. That's that done. We can move on. Sadly, as you might expect, it's not quite that straightforward. So what I'm going to do is I'm going to take that sort of little test and I'm going to break it down for you. So we'll look at each of the different elements. So we'll start with what do we mean in these circumstances when we're talking about employers and employees. What is meant by proposing? At what stage are you proposing redundancies? What is the meaning of redundancy in these circumstances? It's slightly different from the definition of redundancy we looked at in part 1 of this session when we're talking about individual consultation. And then we'll look at calculating your numbers. Have you got 20 or more in that 90-day period? And then we'll finish off this bit of it by looking at what does a single establishment, what does one establishment mean? So let's get into breaking that down. Let's start looking at what we mean by employer and employee. So the important thing to realize when we're talking about an employer is we're talking about a single entity. So the organization or the company that employs the employees. And you are only looking at that entity. So if, for example, you are a company and you have a wider corporate group with subsidiaries and holding companies and sister companies, when you're working out whether any of those companies has an obligation to collectively consult, you only look at each company in turn. So if, for example, you have 10 in 5 different group companies of redundancies planned, that's not going to trigger the obligation. You have to look at the numbers in each individual company. It does mean that if you were really minded to avoid these collective consultation obligations and you'd planned enough in advance, you could have loads of corporate entities and spread your employees far and wide amongst them, and you'd probably never have to collectively consult. I suspect there are very many good tax, organizational, legal reasons, corporate legal reasons why that's not a good idea, but it is the way the test works. You look at each company. When we're talking about employees, we're not, you don't take into account those sort of 0 hours, genuine sort of casual workers and the genuine self-employed. They don't count, but it might include potential employees. So the circumstances where you need to be a little bit careful is where you've made a job offer to an employee, they've accepted that job offer but have yet to start work. If you withdraw that offer as a result of a redundancy situation, they will probably count towards your 20. So when you're assessing your numbers, just be a little bit careful. There haven't been any sort of withdrawals of job offers, because they could count towards your numbers to see whether or not you've triggered collective consultation. Other little catch to watch out for is those employees who are working overseas. 9 times out of 10, they probably won't count. But it is possible, if they can argue they've got a sufficient connection to the UK, that they might need to be included for the purposes of collective consultation, so informing and consulting with them. That is probably a topic in itself, because it's about the jurisdiction of English law, but just be a little bit careful on overseas employees and don't automatically assume they're not going to count towards your numbers. I should clarify that they will only ever count towards your obligations in respect of informing and consulting with them. The Secretary of State, when you have to notify them, is not interested in overseas employees at all. So you discount them for those purposes. So that's a little bit on employers and employees. You then have this idea of proposing to dismiss. So at what stage does an employer sort of tick that box and they start proposing those redundancies? 1,000,001 cases in this area, and they make it clear that it is less than a decision, so it's before you've reached a final decision, but it must be more than a mere contemplation, which kind of follows naturally, because it's going to have some element of certainty to it, so that you can even work out and calculate whether or not your collective redundancy obligations are going to be triggered. You can also be considering alternatives at the time. So, for example, if you were considering making redundancies, or you were thinking about selling the business, the fact that you are considering an alternative, i.e. selling the business maybe to avoid those redundancies, doesn't necessarily mean that you're still not proposing those redundancies. So bear that in mind. And also, your obligations here in respect of being able to inform and consult can be triggered before you know every last detail. So it's always quite tricky to work out at what point in the timeline does you sort of trigger these obligations. What I would say, and so my tip here, is you'll see we're going to come on to look at what you have to do, i.e. particularly this piece around informing and consulting your employees. What I would say is, as soon as you've got sufficient information that you think you could start a process like that, so determine whether or not you need to do it, and then proceed with providing that information to the employees. As soon as you're at that stage, you have probably triggered your obligations in respect to collective consultation. So look at it in terms of when you've got that sufficient information together. Dismissing as redundant, another sort of stage of this test. So those of you who are on the part 1 session, we'll talk there about the sort of classic redundancy situations, i.e. where you have a business closure, a place of work closure, or you've got reduced need for employees to carry out work of a particular kind. All of those will classify as redundancy dismissals. So if you're dismissing employees for those reasons, they will count as redundancy dismissals. But there are other things that will count as well. So firstly, if you have any voluntary redundancies, they will generally be included towards your numbers as well. So when you're calculating whether or not you've hit your 20 and your 90 days, you may need to include those people who have volunteered. The only circumstances where you probably won't is where there is no real risk of a compulsory process being followed. So if, for example, you had a business that was not distressed, but was just exploring whether there was the possibility of any sort of cost cutting, and put out a sort of a genuine, broad, voluntary redundancy offer with no intention of following through with a compulsory process if they didn't get up any takers, that's unlikely to trigger or be counted towards your numbers for collective consultation. But almost any other form of sort of voluntary redundancy, where it's likely to lead to a compulsory process, or could lead to a compulsory process if you don't get the numbers, they probably will have to count. Other things to be aware about is restructures, and where you are seeking to change employees' terms of employment. If you're following a formal process in respect of those, or you are envisaging that those processes might lead to dismissals, they again can count as a redundancy dismissal, even if they're not within those sort of classic 3 redundancy cases of the business closure, place of work, or reduced needs. So just be a little bit careful when you're counting your numbers up, because a wider range of things can count towards this than you might think would qualify as a redundancy dismissal. One, I guess, bit of good news is that if you have an expiry of a fixed term contract, and that generally will not count as a dismissal for these purposes. It may well count as a dismissal for other purposes, like an unfair dismissal claim, but for counting your numbers up, it may well not count. So you can potentially discount those. So we've obviously been talking about what counts as a dismissal. You also have this concept of obviously having to have 20 or more, and it being in this sort of 90-day period. Well, there's a few things to note there. Firstly, and I guess most importantly, the key date for these is when employment ends. So it's not when you give notice to terminate. So you confirm someone's redundant, you give them 3 months notice, and their employment is going to end in 3 months' time. The key date in working out whether they fall, whether you're triggering these 20 in a 90-day period, is the date their employment actually ends, not when you give notice to them. And also, there's been a sort of an established principle that you can discount those that have already been the subject of consultation. So I've given you an example on the slide here to sort of try and explain this a bit better. But if, for example, you review your business and your initial consideration is, well, we need to make 30 redundancies. We're proposing 30 redundancies. And so you've triggered your 20 or more, you crack on with your collective consultation. Something then happens and you realize, actually, this isn't enough. We're going to have to propose another 10, so a fresh 10 set of redundancies. The way the law has always stood to date is you don't need to consult on the further 10, as you've already started the consultation with the other 30. If you hadn't submitted your HR1 form, which is your notification to the Secretary of State, which we'll look at very shortly, then you'd have to include them on there. But broadly, if you started the consultation, you can then discount them from your numbers for any future redundancies. Now, this has all been thrown into a little bit of disarray by a European court decision that came out on I think it's decided on the 11th of November. We still don't have the full English language judgment. It is available in various other European languages if you are so skilled. I am fortunate that somebody else has investigated it and done that work for me, because my language skills are sadly not up to that. But the reason this is potentially causing problems, and I suspect we'll get a lot more publicity when the English language version comes out, is, as you're probably starting to see from what I've talked about so far, our sort of domestic legislation, which implements the European directive that underpins this, is forward-looking. It's very much a focus on your proposals. What are you proposing to do? And are they going to be 20 or more in a 90-day period? So you're looking ahead. What this court says, which is essentially a Spanish case that went up to the European court, is actually the way to look at this is that there should be a rolling 90-day period that you assess on each termination. And you can look forwards or backwards or a combination of them to determine the maximum number of dismissals that have occurred in any 90-day period. So any 90-day period that includes the date of dismissal, which one has the most employees made redundant in it, that's your 90-day reference period. Now, various problems with that. One, logistically, having to assess your consultation obligations at the point of termination on various different employees is incredibly difficult because you've already reached the point of termination. If it then says you've got to collectively consult, you know, that then completely causes problems because you may well not have done that at that point. And it also means that those that are already subject of consultation, or indeed perhaps have already been dismissed, might count towards your numbers falling within this 90-day period. What do you then do if you realise that actually you've had 20 or more in a 90-day period, but some of those people have already been dismissed? What do you then do about that? You should have collectively consulted with them. You haven't done so. How do you remedy that? And this case is quite problematic because the European Court doesn't consider any of these logistical issues. And there might be a slight reason for that. It's a Spanish case, as I understand in Spain, some of these dismissals can be declared sort of void if they are so they don't take effect if they don't comply with the Spanish legislation. But we don't have that kind of principle in this country. So it's a European decision. Some of you will be thinking, well, why does this matter? There's two reasons, really. One is that currently courts have an obligation to interpret our domestic legislation in accordance with the European directives. So they have to try and make it match up as best as possible. And because this case has been decided before the end of the transition period, end of December as we stand, that means that going forward, the courts are still going to have to try and interpret our domestic legislation in accordance with this decision, unless there is a Supreme Court decision that says they don't have to, or new government regulations are passed. But until such time as we get a domestic case that essentially says how this impacts upon our legislation, or indeed we get something from the something that goes to the Supreme Court or some government regulations that clarify this, we've got now this situation of uncertainty in terms of how you calculate your 90-day period. In terms of practical advice in terms of dealing with this, well, the obvious thing to do would be to be cautious. And if you are in any doubt as to whether or not you're going to trigger the collective consultation, particularly with a view to the fact that you might have this rolling 90-day period, that you err on the side of caution and you do a collective consultation period rather than nothing at all. The other thing to think about is whether or not you're able to stagger the dismissals. So under our current legislation, as I say, the key date is when employees' dismissals take effect. There is nothing to stop you staggering your dismissals so that you don't ever trip over your 20 or more in a 90-day period. So you can stagger them over a period of months. So when you're looking at each 90-day period or any rolling 90-day period, you don't actually ever get over 20. Now, that's not going to work for all, because frankly, sometimes redundancies will just need to be done and they'll need to be done quickly, or in other circumstances, the numbers will be such that you'll trigger it anyway. But that is something to think about at an early stage, is how are you going to structure, what's your timeline for these dismissals, and does that impact upon your obligations in respect of collective consultation? So I suspect we'll see more on that decision. As and when we get the English judgment, we'll also be doing a full article on it as well. So if you're subscribed to our updates, you'll get details of that in due course. If you're not, you'll get an opportunity to sign up at the feedback form at the end, I should add. Right, well, we're on to sort of our last step of determining whether or not the collective consultation obligations apply. And this is this idea of, is there, you're counting at a single establishment. So is it 20 or more at a single establishment, at one establishment? Now, more often than not, this will probably be decided by locations. So you'll be looking at individual branch locations, individual retail locations. It will be determined by the place of work of the employees. But that is not necessarily always going to be determinative. you need to look at some other factors as well. So have a look at the permanence of your place of work. So how long has it been there? What's the stability of it? Is it something that it comes and goes, or is it a solid sort of brick and mortar location that's been there for some time and you've inhabited for some time? Also look at your organizational structure and the day-to-day management. How much day-to-day management goes on at that location? To what extent is it has some form of identity of its own? And are your employees organized by that location? So to give you an example, if you have salespeople who are notionally assigned to a particular base, but in reality are very rarely there and actually spend most of their time on the road, you could say, well, actually treating them as part of that establishment isn't appropriate. And maybe your sales group themselves constitute an establishment themselves, i.e. a sort of a group of employees that would be independent to that. I should say that the location or the establishment does not need to be wholly independent. So the mere fact that it might rely upon an HQ for centralized HR, centralized legal, some of those higher levels of management, that doesn't prevent it from being a single establishment. And this case or this issue was called into question a number of years ago. It was sort of the Woolworths case, obviously when Woolworths shut down. And there's a lot of speculation then about whether this test actually stood up and how it should be properly decided. In that case, just to give you an example, it was ultimately decided that each Woolworths store was a separate establishment for the purposes of this test. We haven't had any cases yet on whether or not you can split a site. So I'm talking about the possibility that the location is not the be-all and end-all. And you could have a wider establishment by that. We don't yet have any decided cases on whether or not you could split it down. So say, for example, take a single location and say, well, actually, on this single location, there are two establishments. But it is potentially possible if you've got sort of sufficiently separate structures. So that takes us to the end of sort of our do the consultation obligations apply. You need to look at each element of that and work out whether or not you're going to trigger the numbers. Next stage is, well, what do you then do about it? Assuming you're triggering these obligations, what do you have to do in practice? Well, the first thing to do is you need to notify the Secretary of State. You do that via the form HR1, which you can easily find online. And you have a time period in which to do that, which depends upon the number of redundancies. So if you've got 20 to 99 within a 90-day period, you need to do it at least 30 days before the first dismissal takes effect. If you have 100 or more, then it's at least 45 days. So you've got that slightly longer period. Now, this is important because essentially failure to do so is a criminal offence. And it's not only a potential criminal offence of the employer if someone has consented or permitted or through their neglect has failed for that to have been done. So that could be directors, it could be managers. Then they can also be criminally liable as well. And the sanction is a fine not exceeding level 5 on the criminal scale. And whilst you're muted, I can hear the sigh of relief that it's not exceeding level 5. That can't be too bad. Well, actually, level 5 is an unlimited fine, so that's kind of meaningless, really. So it's quite serious business. There haven't yet been any successful cases brought against individuals for breach of this, despite a few attempts. But you probably don't want to be the first. So just remember, Form HR1 into the Secretary of State, probably the most important bit of the process because of the sanction that sits with it. So that's one part of what you have to do. The other part is basically about informing and consulting with the employees. Before we can dig into that, we need to work out, well, who do we need to be speaking to? And it is the appropriate representatives of the affected employees. Now, one thing which a lot of people miss is that affected employees does not just mean those people who are at risk of redundancy. It also covers those who might be affected by any associated measures. So if you have a group of employees who are at risk of redundancy, but then you have a wider group that are going to maybe have some change in roles as a result, maybe they're going to have some change in duties, maybe change in hours of work, some sort of restructure. Technically, all of them constitute affected employees, and that's relevant when we're looking at, well, who should the representatives be and who gets to vote for them. So your representatives, it can be basically one of three things. It can be a recognised trade union, it can be a standing body of employees, so representatives you've already got in place, or it can be specifically directly affected employees, so employees that have been affected, elected even, for the specific purposes of the redundancy process. Now, the third thing to realise is if you recognise a trade union for any of the affected employees, then they basically get priority. You have to consult with them. Okay, and what we're talking about here is recognition for collective bargaining purposes. We're not talking about union membership. Okay, it's about whether or not you recognize a union and you collectively bargain with them. So you've got your union, but just be careful. If you have other groups of employees that are not covered by that collective bargaining agreement, then you will need additional representatives for them. So you could have a situation where you are consulting with the union and you're also having to elect some additional representatives for those parts of the business that aren't covered by the union agreement. If you don't have a recognised union at all, then you've got a choice. If you've got a standing body of employees, you could potentially consult with them. Not all employers do. And the other alternative, if you don't have that or you choose not to use that, is to have specifically directly elected employees. And we'll talk about that in a little bit more detail in a minute. If you do have to make that choice between a standing body and a specific election, just be very careful about using a standing body of employees. It can be quite tempting, as ultimately they're already in place. You don't need to do an election. You can just crack on and start speaking to them about it. But you just need to check that that they are representative of the affected employees for this process. So that, do they cover those employees that are affected by this situation? You also need to check that they've got authority to deal with redundancies like this, and that they've been properly constituted. So generally speaking, elected or nominated rather than just sort of being imposed by the employer. So let's assume that you don't have a union, you don't have a standing body of employees, or if you do, it's not appropriate. You're then going to have to get some representatives in place. You're going to have some form of election. So a few things to consider. First thing is you're going to need sufficient representatives for the number and the different groups of employees. So think about the overall numbers. Also think about the different groups, different departments, different roles that are impacted, and think about representation for each of those. The reps will need to be affected employees at the time of the election. So if they're not an affected employee, they won't be able to act. You can't unreasonably exclude representatives, and we'd caution against ever trying to exclude a representative unless there are some very seriously good grounds as to why you're looking to do so. You'll also need to be clear when people are standing and indeed when people are voting for them, what is their authority, how long are they going to be appointed for? So it may well be that they're just appointed for this redundancy process, but you just need to be clear on that. And you also need to consider what is the role of each representative. Will, for example, each representative have an obligation to represent all of the affected employees? Or will they have a specific remit in representing a particular group, a particular department, for example? Just be a bit careful. If you are thinking it would be better to have them representing a specific group, that's fine and can make sure that those interests are properly represented. But what it may cause problems, if for any reason your rep drops out before the end of your consultation process, you may need to find another one for that group if you don't have more than one already there, because if that's going to then leave a particular group without any representation, you're going to have to get somebody else on board. Whereas if they're representing all of them, the risks are much less, because you'll probably have a body of other representatives who can carry on despite them a man down. All affected employees at the date of the election obviously have the right to nominate or vote. And then you need to think about your process. So what I would probably say here, and this goes back to the number of representatives you're looking for, is the most painful bit of these elections from a logistics point of view is the election itself. It's this secret ballot piece. And what you might want to think about is trying to avoid that ultimately. And if you get less nominations than the number of representative positions available, then you can just confirm those people into their positions and you don't have to carry out an election at all. So sometimes it is worthwhile to err on the side of generosity with the number of your representative positions, although without being ridiculous about it, because it may well be that if you don't get too many people coming forward, you won't have to run that election process at all. You can also think about how that nomination process would run. I'd normally recommend that you have something which requires people to not only put themselves forward, but have at least one or two backers who confirm their support as well, so that you've got people who are serious about standing. So that's your election process. I've got a question for you all now. Let me get that up for you. Here we are. So, question for you all, so wake you all up a little bit. What should you do if the employees fail to nominate or elect any representatives? So you've gone out to your employees, you've said, please let us know if you want to act as a representative, and they have said nothing, not come back to you. Do you appoint them yourself? You should be able to sort of vote now. You can crack on and let me know. Should you provide information to the employees but not consult with them? Should you inform and consult with them directly, or nothing? It's their fault, they've failed to elect anyone, we can just ignore them. Okay. So this is not always that uncommon, particularly if you've got a relatively small collective consultation process that sometimes no one wants to put themselves forward. Let's have a look at your answers. Here we are. So split. 13% think appoint them yourself, and 88% say you should inform and consult with them directly. Well, actually, none of you are right today. If they fail to nominate anyone, you have an obligation to give information to them directly, but you technically don't have to consult with them. So it is that second option. And that's the way the law works, in that you still have to give information. You give it to the employees directly, but you don't have to do a collective consultation process. You might still need to do an individual consultation process, which you talked about in part 1 to avoid unfair dismissal claims, but a chunk of this collective consultation piece falls away. So, talking about giving information, this is what you'd have to do. So this is what you'd normally be giving to your representatives once you've got them in place. Alternatively, as I say, if you've got a situation where the employees have failed to come forward, this is the information you'd be giving them to directly. So it's all on the slide. These are the things you have to give by law: reasons for the proposed dismissals, numbers and descriptions, total numbers of employees that are proposed being made redundant, and how many in each group, each department. You have to think about how you split that up. How you're proposing to select them for redundancy, so selection criteria, but also your procedure and your timeline. So what's the process you propose following in respect of your collective consultation, your individual consultation? When are the dismissals likely to be effective? And how are you going to calculate redundancy payments? So that might be as simple as statutory payments only, but if you're enhancing anything, you'd need to explain your method for calculating them. Don't have to do the individual sums. It's all about method. It's all about sort of quite high level at this stage. And you also have to give information about agency workers you've got engaged in the relevant part of the business. So the numbers of them, where they work, and the type of work they undertake. So that's the information you have to give. to give it in writing, and you have to give it to your representatives, apart from that one exception we just talked about where they failed to nominate any. And if for any reason you've given that information out early, I would recommend, because otherwise it won't be effective, that you give it out again, you reiterate it once your representatives have been elected or once they're in place. You can provide it in stages, and that may well be appropriate where you don't have all the information up front, or it changes. You need to give it in an understandable format, which you'd think would go without saying. Ongoing obligations, so if the information changes, you need to update it, and the information needs to be genuine and given in good faith. And if it's not, it will undermine the process at all. So if you're trying to pretend the redundancy is due to some reason that it's not, then you run the risk of actually invalidating everything that you have done. So I've got another poll for you now, just to ask you a question. It links back in with what I was saying earlier on. So you remember why I was talking about the definition of affected employees, and it's not only those that are at risk of dismissal, but also those that are affected by associated measures, so restructuring, changing hours, whatever else might be the case. So do you have to give information about those sort of additional measures to your representatives? Yes, no, or I don't know. And I don't know is most certainly an acceptable answer on the basis you've attended a webinar about collective redundancy and therefore probably want to know the answers to these questions rather than already knowing them off the top of your head. Right, let's have a look at the answers. Couple more coming through. There we go, let's close it off. Right, good split here. 64% think yes, 18% think no, and another 18% very honest saying I don't know. And so this is a bit of a wrinkle in the legislation. So the definition of affected employees, as I said, includes these people who are affected by these wider measures, but actually in the legislation there is no specific obligation to give any information about those additional measures or technically to consult with them. It's not in there, and we don't know whether that is a mistake or whether that is a deliberate omission. What I would say is it is possible that if this issue ever goes before court, we haven't got that type of guidance yet, that they may conclude that it is implicit in the regulations that you need to give this type of information and that you need to consult about it. So what I would normally say, unless there's some very good reason why not, it is probably in your interests to give at least some information about those wider measures and have a form of consultation about that as well. If you're going to the problems of consulting about redundancy, you might as well tick off that box as well and cover your backs. So I think we can probably say you all got it right. Those people who said yes, well, you might be right. Those who said no, well, technically that's what the legislation said. And those who don't say I don't know, well, they're right. We're still waiting guidance from the courts on it. But I'd err on the side of caution. So, consultation, we've talked about the information you need to give them. What do you then need to do? Well, you need to consult with your representatives with a view to reaching an agreement with them. So you have to consult when the proposals are still at a sufficiently formative stage. It's not a final definitive decision. And you need to have an open mind and consider the responses and suggestions that you get. And you should record that as well. You can record your evidence that you've had that. Now, the subject matter of the consultation is three things. Technically, it's consulting with a view to reach an agreement on avoiding the dismissals entirely, reducing the numbers that are to be dismissed, and mitigating the consequences of those dismissals, which could include all sorts of things. It could be your redundancy payments, it could be outplacement support, it could be anything. But those are the three things you need to consult about. What I would say is because you have to consult about avoiding the dismissals, it is generally now accepted that you will need to consult to an extent on your business rationale underpinning the redundancies, because your representatives are entitled to say, why are we doing this at all? Can we just not have any redundancies? So you will need to consult as part of the collective piece on that. Once again, as you can see, the legislation doesn't tell you need to consult on those other measures that you're envisaging, but I would recommend that you consider covering that off as part of your consultation. So, timing. When do you need to do all this stuff? Well, technically, the requirement is to do this in good time. So if you assume that there is willingness and good faith on both sides, hopefully there will be, but assume it, how long will it take you to carry out what I've just told you to do, the information and the consultation? And that's your time period. However, there are minimum time periods set down before the first dismissal. And again, this is similar to Secretary of State notification. If you've got 100 or more at any one establishment within a 90-day period, there's a minimum period of 45 days from commencing consultation through to the first dismissal taking effect. And then if it's smaller numbers, between 20 and 99, then it's a 30-day period from the start of consultation before the first dismissal takes effect. And remember, we're talking about when the dismissal takes effect, not when you give notice. Technically, the consultation doesn't actually have to last all of the minimum period. You're required to start it at that 30-day or 45-day prior to the first dismissal, but you don't actually have to continue it all the way through to the end. Most employers will, and it's certainly safer to do it that way. But if you ever had a situation where actually you'd consulted and there was nothing more to say, the reps say there's nothing more to say, there's nothing more to talk about, well, you could potentially close that consultation early. It doesn't allow you to bring the dismissals forward, but you could bring the process to a close early, but only do that when you're on particularly safe grounds that there's nothing else to talk about. Few things to be aware of in terms of the time you spend on this. If there are periods where over Christmas, for example, or you have some sort of shutdown in your organization, you might need to think, well, the fact that I'm consulting for 30 days, is that actually going to be enough when we've got a period of, say, a 10-day shutdown in the middle of it? Also, your consultation process has a limited shelf life. You know, most employers move through this process quite quickly, make the redundancies and move on. That's not always the case. Been cases in the past where these processes have run on for nearly 2 years. And what the courts have said in those circumstances is that the information you've given in your consultation process does not carry on forever. And particularly if, for example, you've envisaged some redundancies, you've then aborted that process maybe because work levels have picked up and you want to pick it up again. Generally speaking, in those circumstances, you'd have to kick this all off at stage 1 again. The other thing to be careful of, which happens a lot but is a slight risk, is if you have volunteers who want to leave early. So you've got your 30 or 45-day period in which nobody should be leaving, but you've got someone who's volunteered for redundancy and I just want to go now. Technically, you can't do it because you'll be doing it before the period of time. What often happens in practice is it's done with caution. So you'd get the representatives to agree that it is permissible, and you'd make sure the individual was doing it of their own accord rather than you forcing them into doing so. Final thing, which is quite an important thing to remember when thinking about your timings, is don't forget your obligations in respect of individual consultation. So focus of this session has been about this high level sort of collective piece on large scale redundancies, but you are likely still to have obligations to do individual consultation as well, because to avoid unfair dismissal claims in particular, there needs to have been individual consultation. So you need to factor that into your timeline. So we're looking at these sort of minimum periods of time, when you're going to start your collective consultation, how long do you need for that? You're going to need to bolt in there somewhere some time for some individual consultation with the employees as well. And that may be a less onerous process than if you didn't have the collective consultation, because you've already collectively consulted on, for example, the selection criteria and things of that nature. But you are still going to have to talk about things that are unique to that individual. So, for example, alternative roles, their own scores, their own questions. Collective consultation, unfortunately, doesn't mean that you don't have to do those things. Right, special circumstances, defence. So, If there are special circumstances which render it not reasonably practicable to consult in time or to notify the Secretary of State, then that is a defence, a limited defence though, to your obligations in respect of informing and consulting and, as I say, notifying the Secretary of State. The reason it's a limited defence is, firstly, it's relatively rare. It is this special circumstances. And the other things is you still have to take all steps to comply as is reasonably practicable. So you have to do everything you can despite those circumstances. And the other thing is it needs to be an assessment that you've reached at the time, not something that you're really just arguing in hindsight. So it's wise, if you ever are trying to rely upon this to some extent, that you record it at the time, and you also probably record the steps that you've taken to comply despite the difficulties that you face. So in terms of when you have these sort of special circumstances, I'm going to ask you a question. So which of the following may qualify for this sort of special circumstances defence? Could it be the need for confidentiality? What if the business is insolvent? What if a controlling party, maybe your holding company, has declined to provide you any information? Some form of sudden disaster? Do any of those count as special circumstances, or is it none of the above? So none of these things are special circumstances and will qualify for this sort of defence against not doing what you should do. So have a guess, see what you think. It's be interesting to know what your views on it are. Right, got some answers then, so let's shut this down and have a little look. So no one thinks confidentiality or insolvency. 22% a controlling party not providing information, which is pretty common in our experience, I have to say, particularly sometimes with overseas holding companies, not always forthcoming with their business plans. Sudden disaster, 22%, and 56%, probably on the basis that you've seen what I've said today in terms of your obligations to apply with these things, none of the above. Well, in reality, it will always depend upon the individual facts. But the cases that we've had today on this area suggest that confidentiality is very rarely going to be special circumstances. And even when you've got sort of obligations as a listed company, they'll expect you to take obligations to make sure your employee representatives keep things confidential rather than just not speaking to them. Insolvency is not in itself special circumstances. Controlling party not providing information isn't a defence. That is highly unlikely to apply. A sudden disaster is possibly the most likely. So something where there has been such a sudden disaster or downturn in work that you've got to make redundancies, and you've got to make them now, and you're not going to get through the, not going to be able to do it within the time frame. So almost instant serious cash flow issues, which means you need to move very quickly. So it's very rare is the circumstances, to be honest, in which this will apply. It's got to be special. There was a case that said that special circumstances need to be special, which was particularly helpful in illuminating this all. But the point was that it's rare. It's not something that would customarily come up, like the need, for example, confidentiality. You could argue that applies in all cases. So I'm conscious of time, I want to leave a bit of time for some questions. So let's move on and talk briefly to finish off about what are the risks. So if you get this wrong, you'll be a declaration against the you failed to comply. And then you have this idea of a protected award, which is ultimately what is just and equitable in all the circumstances, having regard to the seriousness of the employer's failure. Now that is capped, that award, basically at 90 days actual pay for each affected employee that is part of the claim, basically. And this is rather unusual in sort of tribunal law in that it's essentially a punishment. So the employees don't need to have necessarily lost their job. They don't necessarily have to have lost out financially. This is essentially an award that is given to them as a result of in a way of sort of punishing you. Generally, if you haven't done any consultation, the tribunal will start at the maximum and see if there are any grounds in which you can argue it down. And as I say, no loss required on the face of the employees to get the award. They also don't have to have any length of service at all. So it's not like an unfair dismissal claim where they need 2 years service. All of those, even with sort of very short service, can bring claims. What this sometimes leads to is commentators suggesting that it's almost worthwhile doing an all or nothing approach, in that if you run a flawed consultation process, you may, for example, have kept your employees employed for the requisite period. You haven't dismissed them before your 30 or 45 days is up, but then you still end up facing a claim against you for 90 days pay for each employee anyway. And sometimes it's suggested, well, why do that? Well, maybe it's better just not to comply at all. And at least that way you've got rid of the employees as quick as possible, and you only have to worry about the 90 days pay award for each of them. I wouldn't recommend that, I have to say, for 2 reasons. One is obviously there are implications here in terms of these flawed processes beyond just the legal ones. You know, there's reputational issues, there's business issues. The other thing, of course, is that you might want an arguable defence to a claim. If you do nothing at all, it's going to be very clear you've breached and there's going to be no grounds for negotiation, and whoever's pursuing the claim is going to be looking for the maximum. If, however, you have run a process, even if it's not perfect, the likelihood is you'll still have some arguments to say that you've ticked the required boxes. So please, any questions, please let me know. I'll open up the question box in just a moment and answer as many of those as I can in the time we've got left. I should also flag up before I do that, we have our next webinar as part of our November webinar sessions is next Tuesday, which is on the much nicer topic of how do you retain your key employees in a COVID world, and my colleague Louise Smith is running that session. And also, obviously, I've referred during the session to part 1 of this, which was done on Tuesday, which is about individual consultation. If you didn't catch that, you can find it on our website or on our YouTube channel. And also, when we do finally close the session, I'll do the questions now, but once I've done that, and when I close the session, you will have the opportunity to give some feedback on the session. So it's only a few questions. If you could stay on for just a few seconds after I've closed it down, that would be great. Right, let's have a look at the questions. Start off with, in your experience, how often are claims made? Very good question. I think it depends. I think there is, so the number of claims has increased, much like the individual claims, no doubt will increase further because of the pandemic and the fact that more of these processes are ongoing. So we do expect to see more of them. A lot of it actually has to do with the nature of your representatives. If you're in a unionized situation and you've got experienced union representatives, if you get this process wrong, the likelihood is they're really going to know it, and they are going to then pursue you on behalf of their members as a result. You know, the unions always want to make sure that they're looking after their staff and their members, and sometimes pursuing a claim on their behalf is frankly quite good advertisement for the union services and how useful they are. So I'd be particularly careful when dealing with a union, because I'd say your risk of claims is higher there. If it's a relatively small scale redundancy done through elected representatives, your risks are much, much less. So if you've got sort of a 20 and you've got a few employee reps, if you've broadly done what you've meant to do, I would say your risks are probably relatively low. But as with all these things, it's not just doing what you should do, it's also being seen to being done. What you don't want to do is do anything which arises any suspicion or causes anyone to go off and get legal advice. Another question here, which is a good one, which is about how do you deal with the need for changing in consultation, so new groups or additional numbers being added during the process. Well, I think it depends. I think where it's relatively easy is that if you've got sort of additional numbers within your sort of already represented group of affected employees, the likelihood is you could potentially provide that additional information through to your representatives and consult with them about it. Where it's more difficult, possibly, is where your representatives don't represent your group of affected employees. And there you'd need to potentially consider a fresh election to get the appropriate representatives in place. But do remember that you might be able to discount those employees have already collectively consulted on. So if, for example, you only add in a small group of additional employees at risk, 5 or 10, you might be able to argue, well, actually, you don't have to trigger collective consultation for them at all. Question on settlement agreements in redundancy situations. Would I recommend them? I think it depends. I think if you are enhancing redundancy payments, particularly if you're giving a generous enhancement, I would normally recommend you get a settlement agreement, because that's the only way that you're going to get certainty that they're not going to sort of take that money and still pursue a claim against you. There are some technical difficulties with settlement agreements actually settling claims relating to claims for failure to collectively consult. But if you have a well-drafted settlement agreement, you can avoid some of those concerns. You can sort of include some indemnities and some offset wording, which reduces that risk. But I definitely recommend them if you're enhancing. I also think it depends on what you're looking to achieve. If you're able to secure settlement agreements quite early on, it may well be that you can circumvent a large amount of the process you would normally follow, particularly around individual consultation. So there are some advantages. It's weighing up the additional cost of the settlement agreement, basically, as against the benefit to you as an organisation. You don't have to do them, because ultimately, if you get the process right, you should be on reasonable grounds. Question here, what does consultation involve in practice? So yeah, I guess in very simple terms, once you've got your representatives in place, obviously you've got that stage where you're giving the information to them in writing, as I've talked about. After that, you've got some flexibility, but certainly what we'd normally expect is regular meetings. Obviously, they might be virtual at the moment. You'd probably want to have some form of agenda for those, particularly if you've got not particularly experienced representatives. You can sort of guide them through the process and what's meant to be achieved. You might also want to think, particularly if you've got employed representatives, you might need to think that they're going to have sufficient time to comply with their obligations to act as representatives, so sufficient time off for work, and also have a think about whether maybe you might want them to appoint a chairperson or something of that nature, particularly if you don't want, if you've got a large group of representatives, you don't want them all sort of emailing information through or questions through. You might want to funnel it through a little bit more. But essentially, it's not that dissimilar to individual consultation, just on a group scale. It's about ensuring that you've given them information, recorded the feedback, considered it, gone back to them. It's almost akin to a negotiation, or it should be, because you're trying to consult with a view to agree. Right, we'll do one more quickly, because I'm conscious we're near the end of time and I want to finish on time. Yeah, okay, we'll do this one. Interacting with individual consultation. So how does individual consultation interact with the collective consultation? Well, you can potentially, there's nothing to stop you starting individual consultation whilst the collective consultation is still ongoing. But what you need to ensure is you don't start it so early that you're cutting across the collective process. Ultimately, you want to sort of almost conclude the collective process in respect to those sort of high level things like the selection criteria, like the numbers, like the alternatives to redundancy. And only once you've sort of gone through those processes, move down to the individual consultation. The danger if you start individual consultation too early is, firstly, is it undermining the collective consultation process? And secondly, you'll probably end up speaking at those individual consultation meetings about various things that should be considered at collective level. So you'll be duplicating work as well. Right, well, I think we'll leave it there. Other questions, I'll ping an email to the person who's asked them and try and come back to you separately on those. But thank you all very much for attending. Hopefully you've found it useful. If I'll close the session now, but if you can hold on just to provide a little bit of feedback, that would be really appreciated. Thank you all very much. Have a good day.